Signing a lease or purchasing a property in Panama doesn't start at the notary. It begins with deciding how much control you want over each step. If you already live in the country and are buying, selling, or renting a property, it is wise to understand the legal scope before deciding on the price. To get things under control, it is worth answering 3 specific questions. What does a real estate lawyer do in a transaction? How much do they charge to advise you on a sale? And what rules establish obligations and limits for each party? The lawyer work begins with due diligence that leaves no loose ends, verification of title in the public registry, search for liens and precautionary measures, review of easements and boundaries, analysis of the land registry and zoning, review of the horizontal property regulations when applicable, and verification of tax or property debts. Based on this, the firm proposed the conditions, deadlines, and documents necessary for the business to be executed and registered without any problems. Then comes the preparation or review of the contract that supports the transaction, purchase promise with clear contingencies, leases with defined inventories and warranties, leasing scheme when applicable, and loans agreements linked to the closing. This includes notary procedures, coordination of the deed, registration of the transfer, and, if necessary, updating it with an ATI, obtaining a clearance certificate, and comparing plans with physical reality of the property. When these steps go unchecked, familiar problems recur, encroachments or boundaries disputes, flawed titles, misinterpretation of the horizontal property regime, unpaid leases that escalates to eviction, and even annulment due to format errors. Now, regarding the fees. In real estate transactions, they are usually agreed upon based on the value of the property and the representation rule. As a market benchmark, sales consulting fees range between 1% and 3%, adjusting depending on whether the client is the seller or the buyer, and the complexity of the case. For specific assignments, such as a specific consultation or a contract review, it is common to work by an hour or define a fixed, closed scope. A specific profile is involved in the negotiation. The real estate transaction lawyer who translates the due diligence finding into enforceable clauses, coordinates with banks, notaries, and counterparties, and aligns deposits, schedules, and delivery conditions. The real estate broker can identify opportunities and mediate to search. The lawyer ensures that the arrangement is compatible with the legal framework and that the closing is completed with complete documentation that can be registered with the authorities. The legal framework is not a single law, but rather a system that works together. The civil code and the public registry defines how ownership arises and is proven, and Law 284 of 2002 establishes the following. Law 284 of 2002. Horizontal property. The horizontal property regime is created as a special type of property with functional independence, where private and common property coexist. To incorporate a project into this regime, the same law requires specific documentation, approved plan with municipal seal, cover page, co-ownership regulations. Extract from the law. For this purpose, plans previously approved by the competent municipality authorities and the project's co-ownership regulations must be provided. This link to zoning and municipality regulations that determines uses and densities. And regarding competition within this system, the law provides regulatory review board, technical board minutes extract from the law, review and approve the co-ownership regulations for properties to be incorporated into the horizontal property regime, and their respective reforms in accordance with the established requirements. Together, these rules combined with administrative and municipal regulations affects permits, changes, and pre-registration requirements. Therefore, knowing which regulation applies to each stage avoids unnecessary rework and cost. For foreigners, these processes often intersect with immigration, banking, or corporate needs. At this point, it's helpful to have a team that integrates complementary legal aspects like NDM FIRM and Associates, for example, which is a Panamanian law firm that assists foreigners in immigration, legal, civil, and commercial procedures. When a real estate transaction depends on a bank account, a company, or a residency, coordinating under single strategy reduces time and friction. With this in mind, it is worth clarifying that the real estate law in Panama covers in practice. It regulates the ownership, use, transfer, and development of real estate, including titles, sales, and lease agreement, plus mortgage, horizontal properties, zoning, and deed registration. In operational terms, its objective is to provide legal certainty at every step, from the promise of the final entry in the registry so that the economic agreement becomes a real right. Now is your turn. If you've ever bought or rented based solely on word of mouth, and then things didn't go as planned, what happened? Tell me what you wish you had written down to avoid these unpleasant experiences, and what lessons you have learned. Your experience can help other residents decide on their own for their next purchase. If you got to the end of this video, thank you for watching. And of course, if you are interested in purchase a property, rent an apartment, or sell it, or any real estate business, you can definitely contact NDM for legal advice through our website, www.ndm.com.pa, or you can always leave a comment behind with your questions. If you like this video, give us a like, subscribe to our channel, leave us a comment, and don't forget to subscribe to our channel. Thank you for watching again, and I will see you in the next one.